and many more. No, Solomon. But yeah, cause we didn't come on, it was a free parliament. Abba and Ra. Now, you share from the political point of view. I had the political science lectures I didn't come on. Now, you share the legal aspect of it from the legal point of view. Now, you have a better understanding where it is coming from, the implications, and of course, the constitutional basis for this very particular and come on across our parliament. On phone, a lawyer. Enoch Anhwere Afoakwa, or a private legal practitioner and a member of the NPP. Ewa humanos. I mean, the basic understanding of this ruling by the Speaker of Parliament. Lawyer, Mache Emma Akwa by the bar Odia 95.2. I'm meeting the JB. Bibi Aboko. Very well. Very well. But that's the same when I'm ready. Now, you hear the legal interpretation of this very particular ruling. The Speaker of Parliament, Ediba Enra, it declared 4 seats vacant in our Parliament.
JB.
Yes, sir.
The medical can say, Enra that the CEO Ghana Mrashibi Gemuno, will amount to what we call, we can term say, the Parliament of Ghana's Day of Shame. It can say, Untiminye say, Muna Musishemra, Naso Mubu Embraso. And no Emma Ghana Mrasebigano Enemeguasi, and rather. Now, you set a very serious and dangerous precedent, and the Diato Honomoa say, Game Court about time Supreme Court, no, am Bemuhandi to resolve this challenge. Our better is here now. There will be chaos in Parliament in the future. The intention of the draftman, as far as 1992 Constitution, envisages Nema way, will be thwarted. Maybe edited America. Usha Yemra Kunina under Article 131 of our 1992 Constitution, it granted exclusive original jurisdiction to the Supreme Court as far as the interpretation and enforcement of the Constitution. The 1992 Constitution of Ghana is concerned. And it's a basse, yen church, Emran, you said the Emran air car, and yet any other body, and your man penny and Adam Kufuado, and yet Speaker of Parliament, Right Honorable Alban Kinswasman Babin, the Supreme Court, courts not properly constituted, no, and it may interpret a provision of the Constitution, near the finality ever. And only to me, I am Supreme Court, and it's a kind of say exclusive original jurisdiction. Court to be any Ghana, administrative body be any Ghana, no more. Supreme Court, and we almost share that sort of jurisdiction, It's a jealous provision, and a Supreme Court,
Now, so Council, about to say, the one will ask, say, then what is the purpose of Article 97 in the Constitution?
The purpose of Article 97, preserve the composition of Parliament as constituted by the Ghanaian people. The composition of Parliament as constituted by the Ghanaian people. Yenjintum say, Mrasebejebia a unique of itself. And until now, you name every Parliament, Yenya compose Parliament, yes, where members of Parliament in ye elected speaker now. Yes, Parliament we a 7th Parliament, a 8th Parliament. Currently, we are in the 8th Parliament, and a year for the 9th Parliament of the Republic of Ghana in the 4th Republic. And the life of every Parliament is unique. And it's a Ghana for Akotwaba. Na Ghana for say Yama NDC. Mrase Bedrafon Kunyano Makumako 137. Yama NPP, Amanyuku no Mrasibia Kunyano 137. Yet the independent Bakwa so no made dentemu na Omuama adventure and Conso de Beya, Ghana phone puntun and Kankra Yepen and Sabeka, Namrasibia Etimia Plessy, Etimia undertake Omu role as oversight over the executive, now boy, Amagana, Etimian Puntun and Kankra. That is the sovereign will of the Ghanaian people. It's the decision that the Ghanaian people made. And basically to protect that, Article 97, Ebo by say, MPP mind a 137, now over to me, Uncle Kasebi Waka appointee Haruna Idrisu, a member, Minister of State. And based on that, Yeri Haruna Ibris will feel say, Ebia MPP Ashira Nimunyam, and or cross carpet within the life of that parliament, Abe joining MPP Amayokori because or contested election or Tamale Central on his own accord and the ticket of the NDC. And Odruma Sibejoma would the OPBR. And no, that provision the bomb home.
And how does it apply to these 4 members of parliament?
Absolutely. So Oka say apply and now judge the actions of these 4 members of parliament, i.e. Yera Kwatiaka of the NDC from Memphis Central, Yera Kojo Boateng of Suhum on the ticket of the NPP, Yema Cynthia Mamle Morrison of Aguna West, and Honorable Esiama, independent member of parliament for Mina. Obieni Honomoa, Wachrokrata, Asevi notice, Amam Rasibija, and Anani party a womb. So on the party, no, a divorce the relationship they have. We're free party or woman, we're free caucus or woman, a bit changing the configuration or the composition of the arrangement in parliament. They almost declaring a future intention for the 9th parliament, if successful, or more no ever join it, they also join the NPP, or call the ticket of the NPP for the 9th parliament. They also person or remain in parliament as an independent member of parliament, for the 9th parliament, but not for the 8th parliament. Edwiti says Speaker of Parliament arrogated to himself the powers or the jurisdiction of the Supreme Court under Article 130(1)(a). Now, or interpret the Constitution, now no answer composing itself, now or undertake the jurisdiction of the High Court under Article 99(1)(a) to declare a seat vacant in Parliament, which is the jurisdiction of the High Court of the Republic of Ghana. Na emu are huye, na eyenguase, na eyemra yemu some organs of government, the emran enemy form. You see, every Speaker Baben, every Speaker of Parliament, the actions and ni actions in na or try to arrogate the supremacy of the Constitution, to that of Parliament. But Ghana ye Parliament no supreme. It is the Constitution, 1992 Constitution, that is supreme. It is all other constitutional bodies, eshe embrana say, bro embrana so. It is any action of any constitutional body biana or administrative body biana, inconsistent with the 1992 Constitution. Any citizen like JB, yourself, myself, can go to the Supreme Court under Article 2.1 and invoke the original jurisdiction of the Supreme Court under Article 131(a). Say court, MFA and 2 years, and say inconsistent, a court now render null and void.
Is it to say, sir?
Year after your markings, 2 years, kind of say Parliament, I'm the status quo procedure. Yede Yamam Brand X-ray, or book, or Bubusu, or Nakadane, or Modani, or Court, a ruling, interpreting Constitution, as I done in the High Court, enforce declaring the seat vacant in Parliament, any such to me.
Is it to say, sir, this particular article, our Constitution, may too ambiguous to the point where you be here interpretation from the Supreme Court, Anna?
Very well, clearly stated. Article 97(1). G and H now. JB, NDC, for NDC lawyers are almost subscribed to the social democratic ideals and principles. Apply a specific interpretation to that provision. Yes, so no, who's that provision is also in a different light. And Yebeka said we are giving rival interpretation to a provision of the Constitution. And no, and I will share your Constitution now. Under Article 132, say even a court below. When the question of constitutional interpretation arises, I was a court, estate proceedings, not refer the question of constitutional interpretation, to the Supreme Court. The Supreme Court, interpret now over court below, whether High Court, Court of Appeal, Circuit Court, District Court, or whatsoever regional tribunal, I enforce the decision of the Supreme Court. The Court Act of 1993, Act 459, is also under Section 10(6). Of the Court Act reinforces the same provision of the Constitution. And so even the courts, properly constituted or more judicial authority, clothed with judicial authority, under Article 125, anyone to me say, when even a constitutional question, interpretation or enforcement, arises before them, or go ahead. And you see, now your position of the Supreme Court be in the what we call the Mekankan principle. I will be a wasted interpretation be in the Ghana School of Law. Ebeja to be a lawyer, be to say the Mekankan principle no stated say when the provision of the Constitution was clear, the court below must enforce it. And can we read say the literal interpretation or literal meaning what you say no, which me apply. But during the expertise and network case, Ebra Yera near Marshite, no, a day, Yamame, Senator Jimmy Rollins, Echo High Court, no. High Court judge, Justice Kwekuti Akabuafo, and now he's a Justice of Appeal. Eka said that provision under Article 94 was clear. Say you must be a registered voter. And son what me, Edu was say, Yento, so Abana Mayam Rasibidrini. And when he say NDC Akuyi, Yenuaba, Senator Jimmy Rollins, not on your registered voter there, then she was not qualified under the provision under Article 94 because the provision was clear. This is the statement or the judgment of the High Court, Accra, presided over by Justice Kwekuti Akabuafo. When this position of Justice Akabuafo was appealed to the Supreme Court, in the ex parte Zaneto case, the Supreme Court, speaking through Justice William Matuguba GSC, as he then was, can say the High Court stating that the provision of the Constitution under Article 94 is clear because Zaneto and registered voter on your qualified, amounts to interpretation of the Constitution. The High Court has no jurisdiction because the moment Waka say clear, it means that you have undertaken some semblance of interpretation of the Constitution to arrive at the conclusion that the provision is clear. And from the decision of ex parte Zaneto, Supreme Court Amayati said there is no clarity insofar as a rival meanings or rival interpretation are ascribed to any provision of the Constitution, where the question of constitutional interpretation arises, the court below must stay proceedings and refer the question of constitutional interpretation to the Supreme Court for interpretation.
See, very interesting. Yeah.
Majority Canadian, minority Canadian on their motion, majority Canadian. And once rival interpretation has been ascribed to Article 97, 1G and H, the Speaker was enjoined under Article 132 to stay proceedings and refer the question of constitutional interpretation to the Supreme Court, not the Supreme Court. The Amma Speaker no into Sana Morning say na more premeditated motive be say be taking over Parliament because a few days near Kotwaba. The life of this Parliament just about 21 cities sure so group as a normal rising for the elections in Manema. And to cause crisis in Parliament and to cause this grave confusion in Parliament, is something Yera Abans Smarkins for Babe. Our most experienced parliamentarian the Fourth Republic has ever produced, We're tainting the credibility, we're tainting the experiences, we're tainting the standing as far as the light of the rule of law are concerned in the Ghanaian jurisprudence.
Interesting. Now, so you share one interesting. Now, you hear the judicial review, the judicial interpretation of this very particular article. That is 97 clause, 97 1G and H. Now, what is likely to happen? Per the Speaker's decision, contrary to the Speaker's decision, the court.
One, the court has the power to declare. The case of Justice Abulai versus Attorney General recently on the quorum matter now Parliament say the business of Parliament in a closed book because they are masters of their own rules, and the court cannot come in handy to determine certain actions of Parliament or to render certain actions of Parliament null and void or unconstitutional. But in the Justice Abulai versus the Attorney General, the Supreme Court can categorical. The Supreme Court was stated a definite position. Say yes, the business of Parliament, they are masters of their own rules, subject to the Constitution. And the Supreme Court upheld the constitutional supremacy in that ruling. The Parliament, they are masters of their own rules. But the was a far and so na any constitution your 1992 constitution and no any penny HDBA e Ghana ha ye nyina ye ti ehase no e was any question in the webra the rather Speaker of Parliament what change the composition and the configuration in Parliament and then your constitution e webra. So I will not be surprised say the Supreme Court at the better be that say the we will have a binding precedent to follow as far as some of these determinations, any processes, any procedures, are concerned.
Did the Speaker add?
He gravely erred. Not just erred, he gravely erred. Every occasion said would differ the ruling into a subsequent date. I felt and I thought, say, as experienced as he was, for a broad consultation to see. Now, Obebanoa be differ in the ruling, to say, here Rafael Markins, I file for interpretation of Article 97 before the Supreme Court, or the state proceedings, now what can say ruling another interpretation from the Supreme Court, a bar. or the parliament at the Ayejuma. Neso no or per se on the court because you ocean actions and many inactions via now. The Right Honourable Speaker of Parliament, with celestial respect to his office, tries to obey raise Parliament as supreme than any other body in the Republic, which is inconsistent with the provision of the 1992 Constitution. So the Speaker of Parliament clearly erred as far as the ruling and declaring some 4 seats in Parliament vacant is concerned.
Very well. Very well. Because I mean now I say na I'm grateful for your time.
Thank you.
Lawyer Enoch Anhwere Afoakwa, a private legal practitioner and of course a member of the NPP on the NDC Common. Very interesting dynamics.
Onua 95.1 FM. 95.1 FM. Yeah,